The issues in debate over California's AB-5 started in 2005, when a delivery driver in California filed a lawsuit alleging that he was misclassified as a contractor. He claimed that he really should have been an employee to receive fair compensation for his work. 13 years later, in 2018, the case was decided by the California Supreme Court in DYNAMEX Operation West versus Superior Court. The court concluded that the driver is an employee for purposes of the state's wage orders, which establish minimum wages, rest and meal breaks, and so on. To reach this determination, the court introduced an ABC test, discarding a test from a 30-year-old case, Borrello & Sons, Incorporated versus Department of Industrial Relations, to determine who was an independent contractor. The business community responded that the court, in effect, created a new law. The controversy culminated with the California legislature adopting Assembly Bill 5, AB-5, codifying the ABC test in California not only for wages, but also for unemployment insurance and workers' compensation purposes as well. AB-5 went into effect on January 1, 2020, but the controversy continued. AB-5 created approximately 41 exceptions to the ABC test. Lawyers and doctors and real estate agents, for example, have exceptions. Exempt professions get to apply the old test, Borrello, the test which the Supreme Court discarded. In effect, the bill creates a test to determine which test to apply. Eventually, about 31 bills were introduced to amend or repeal the law, and they were whittled down to one, AB 2257. This bill, recently signed into law, adds approximately 26 more exceptions and also tweaks some of the current exceptions. But AB 2257 does not alter the basic framework of the ABC test, nor does it address gig economy workers such as Uber drivers. Californians weighed in on that question on November 3rd by voting on Proposition 22, which determined that app-based rideshare and delivery drivers are exempt from the ABC test. But how about all other workers? The rest of California is still grappling with numerous, significant, unanswered legal questions related to independent contractor status. A broader policy discussion has yet to take place. What about workers who still want the flexibility of contract work? Or what about the independent owner-operator model of the trucking industry and other industries? And will this change the relationship between franchisor and franchisee? It appears that these and other important questions will need to be resolved in the courts.